Khaya, good morning, and thanks for speaking to us here on Morning Live.
Good morning, and good morning to the viewer.
So here we are again with Takatso, and this time court cases, Toto Investments, they were unsuccessful, one of the unsuccessful bidders setting their eyes on buying that stake in SAA. However, is there any justification in their court application at this stage for having the sale of that 51% stake of SAA set aside?
Well, I suppose the difficulty here is that if Toto is accurate in its assessment that there is something very suspicious about the choice that was made by the Department of Public Enterprises last year to elect Takatso Consortium as the winning bidder, if there is something wrong with that, then you'd have to question the merits of any court saying that, well, actually let the deal proceed, because at the crux of the issue is the fact that Toto Consortium alleges that, look, a process was undertaken. RMB, the investment bankers, were appointed to look at everybody who said, we've got an interest in taking a stake in SAA. And RMB, having been appointed by the Department of Public Enterprises, came back with the conclusion that everybody who had put a bid, and there were about 30 companies that had put a bid, everybody was simply not able to meet the requirements that had been set by the department. So when that process was completed, it then appeared that Takatso and whoever is involved in Takatso were able to still bypass that process by approaching the department directly and saying, look, even though everybody has lost out according to the RMB assessment, we have the capacity, we have the ability to proceed with the deal. And that's what the Department of Public Enterprises embarked on. So obviously, any losing bidder would be curious, if nothing else, to find out that, well, if the appointed service providers, which was Rand Merchant Bank, said all of us were not good enough, what is it that Takatso then did differently in the interim or in the subsequent period to then motivate to the department that they should be allowed to actually proceed with the strategic equity partnership? So I think the question is a remarkably relevant one, not just for Toto, but for all the other bidders who actually lost out in this transaction.
And with regard to just having access to the relevant documents, so the court has now given the department 20 days to make those documents available. And the whole issue of secrecy around this, Khaya, is that something we should be concerned about? What would be the reasons for the secrecy around some of these documents?
So in any transaction of this nature, there are definitely some very commercial issues and some commercial sensitivities that you'd love to protect. So if you were trying to sell a particular business and you don't want those that are currently competing with that business to sort of know what its great competitive advantage is, then there is some merit into saying, let us ensure that none of this information makes it to the public domain, because our competitors will now know what exactly it is that distinguishes us from them. So that is what the big consideration would be in any transaction. In the case of South African Airways, however, the issues are slightly different in that not only was it a public entity, which means that actually a lot of its information is in the public domain first and foremost, but also quite crucially, remember what happened before we ended up with this particular strategic equity conversation is that it underwent a business rescue process. So when it underwent the business rescue process that started in December 2019, it simply meant that the business rescue practitioners, Matusol and Ndongwana, actually had to then put together some form of information that then made it very clear to the existing shareholder, which was the Department of Public Enterprises, what the state of affairs was. But also, quite importantly, that information then had to be made available to anyone who had an interest in acquiring a stake in the restructured airline. So a lot of the commercial issues relating to SAA were already in the public domain. So it's very difficult to imagine that there's some additional insights or some additional information that is so commercially sensitive or so market sensitive that the Department of Enterprises feels that if it ever had to be known to the competitors of SAA, that would be fatal to the operations of SAA. Our airline market and our aviation market quite simply isn't that complicated. So it's very difficult to imagine what it is that the department says absolutely cannot be known by anyone.
And if we look at some of the allegations that are swirling around, Khaya, and also now looking at those bidders who are unsuccessful, also now trying to see whether they can get more detail. You've got the DA, you've got the UDM also saying, you know, looking at this with a bit of skepticism. So what's the end game here? Because SAA is now saying that the onboarding of Takatso is a priority, and that if that deal does not go through, they could then possibly, go down. So let's talk about that. Considering where things are legally, what are the chances of this deal actually being reversed?
So there are a couple of complications in that particular question that you pose. In that, first and foremost, when this deal was announced last year, it really was a deal that sounded like it was imminent. It sounded like within a matter of moments or a matter of weeks, we'd actually have a new strategic equity partner that was going to be running the airline. And of course, that equity partner would ensure that South African taxpayers never had to bail out SAA after that. So that was the impression that was created by the Department of Public Enterprises when the announcement was announced, or when the announcement was made. Since then, it has become remarkably difficult to find out the state of affairs. So, of course, the expectation was that, look, once you've decided that these are the winning bidders, you've only made that decision on the basis that they've got the capacity to essentially run the airline, they've got the capacity to finance whatever is necessary to get the airline back into the skies. Quite ironically, after the lockdowns of COVID-19, the airline did take into the skies, but it wasn't an airline that took into the skies because Takatso got it back into the skies. We actually still have no idea what it is that SAA was able to do in order to be able to get back into the skies. It doesn't look like it was because Takatso had done it. So the issue here is that, well, if SAA could get back into commercial operations without the Takatso deal being finalized, just how critical was the Takatso deal to its viability? That is something that remains completely unknown for a lot of people. But also on a secondary basis, then there's the question of, well, given the fact how long this particular transaction or this particular leg of the deal has essentially stalled, and the fact that SAA is actually in operation, you have to wonder who's actually financing the operations of SAA at this point in time. And of course, the Department of Public Enterprises has taken the view that we as taxpayers do not need to know who is actually funding the airline right now. All we get to hear about is that, well, there's another 3.5 billion rand that we committed to, even though a lot of South African taxpayers do not remember that, even though the former finance minister, Tito Mboweni, doesn't seem to have the same recollection. It does appear, according to the Department of Public Enterprises, that we made a commitment to make another 3.5 billion rand available. Whether that's the 3.5 billion rand that's making SAA able to fly even today, absolutely nobody knows.
So considering that and the fact that the 51% stake will see Takatso invest 3 billion over 3 years, like, what's happening? Where's the logic?
So what was put together in the public domain was the fact that not only will Takatso acquire 51% stake, which of course for them is a strategically important number because at 51% you are in the simple majority according to the Companies Act. You can be able to execute on a lot of at least the operational decisions without having to make another phone call to anyone else. However, beyond the 51%, we were told yet again by the Department of Public Enterprises that they would retain a golden share, which simply means that there are particular decisions, there are particular transactions that the Takatso Consortium would never be able to execute in the absence of the concurrence from the Department of Public Enterprises. So that's as much as we knew about what the structure was going to look like. Now, the question of how much money needed to be put in order to get us there then became a contentious matter. So a lot of people remember the 51 Rand number became a big talking point. Now, obviously, it wasn't because the airline was worth 51 Rand. It was simply because the airline was worth nothing. But in order to be able to facilitate the exchange of the share certificates from the Department of Public Enterprises, which owned all 100 share certificates or 100% of the share certificates, in order to be able to get Takatso to own 51% of those share certificates, you simply have to find a way to transfer them, and they decided on a nominal amount of essentially 1 Rand for each 1% stake. So that's where the 51 Rand came from. It was never a reflection of the underlying value of the business. The problem, of course, is that nobody really knows what the value of the business is, because from the business rescue process, we got particular numbers. RMB looked at those numbers, they compared the 30 bidders, what they had put together, and they said, look, none of you actually seem to be in a position to take over this airline in a manner that the department has proposed, so therefore that's why we're rejecting all of you. And Takatso somehow managed to find a way to get that done, and that is what this court case should have enabled us to understand, because what Toto was asking is to say, well, give us the insights into how the decision was reached. So give us access to the information that the department had in its purview that then said to them, never mind what RMB has told us about all the other bidders, including the Takatso Consortium, this is what we're going to do and this is how we're going to proceed.
And this is, of course, where it becomes so confusing, Khaya. You know, you listen to all of this. This is an entity that hasn't presented financials in the last 5 years. You know, when you talk about how much is it worth, how do we know? Because everything is either shrouded in a veil of secrecy, or there's just nowhere to go to actually get a glimpse of what is happening with the financials of this entity. And then with this Takatso deal now, you have the 20 route licenses that were actually withdrawn. So that makes the deal, of course, a lot more unattractive for Takatso, given that SAA has lost those routes. So again, they've been saying, as you pointed out earlier, that this deal is imminent. But when?
So actually, we do have an ability to understand what the financials are, not because the auditors came in and said this is what the state of the airline is, but because in the business rescue process, what the business rescue practitioners had to do is essentially figure out the state of affairs. So from what we read in the business rescue plan, unfortunately, COVID-19 happened, which simply meant that all aviation companies by default were simply undervalued at a particular point in time. But also, quite importantly, in relation to SAA, we were then able to see that its sum of existing liabilities were so enormous, there wasn't much value to be allocated to the airline, with the exception of what is a primary asset for every single airline, which is essentially the landing rights, the rights to be able to fly onto particular locations at particular time, which is the most lucrative aspect of it all. That, unfortunately, is the same asset that has now come under scrutiny, as you said, because a couple of weeks ago, we then heard that the International Licensing Authority had suspended 20 of those particular routes. In other words, if SAA had been built on the business model that will be able to fly people to London on a daily basis, for example, if the licensing authority says, look, you are no longer able to fly into London, then that revenue stream disappears overnight. And remember, the most important part of that is that one of the reasons that are cited by the licensing authority is that, first and foremost, we have absolutely no idea who runs this airline. And that's a very critical question, because an airline is not like your spaza shop or my spaza shop where literally no one cares whether we go under over tomorrow. When an airline exists, a lot of people tend to spend their money way in advance with the hope, with the expectation that by the time Christmas or Easter comes around and they want to fly, they'll be able to do so. So every single licensing authority has got a vested interest in knowing that whoever is in charge of the airline, whoever runs that entity, is financially stable or financially viable enough to ensure that the airline will still be there by Christmas when it is supposed to be, when the time is supposed to come for us, for you and I to fly on that airline because we've booked. So in instances where you can't even explain who owns your shares, where you can't even explain who's in charge of your organization, licensing authorities tend to frown upon that. And that is what we are now seeing becoming the new issue, the emerging issue for SAA, in that until the Department of Public Enterprises either finalizes the deal or alternatively decides that the information that is necessary for us to understand what's going on should be in the public domain, this is just the beginning of a much longer and an escalating crisis.
So the DPE's acting DG told Parliament recently something that was interpreted as saying that if this deal with Takatso falls through, government cannot put any more money into SAA, and that the only option left then would be the liquidation of the airline. And obviously we've seen this before in this business, but looking at the case of SAA and just the number of jobs that were lost, for example, and again, SAA taking to the skies sans Takatso and the South African taxpayer forking out money again. Should anyone be held liable for this course of action, of events that took place? Or is it just okay that this is something that happens in the line of business and so it went?
Look, I do not share the view that this is an ordinary transaction where you and I quite simply have no moral authority to question the things that are going on here. SAA is unique in the sense that in order for it to even make it to 2022, taxpayers have had to dig deep. Taxpayers have had to dig deep and very frequently in order for it to remain operational, because even before the COVID-19 pandemic, this was an airline that was simply struggling to actually ensure that it remained viable. You'll remember that even its business rescue process happened in December 2019, weeks before we actually understood the scale of the pandemic. So SAA didn't go into business rescue because of COVID-19. It went into business rescue because it was quite simply not functional as an entity. So the key issue here is that obviously, as South African taxpayers, having spent so much on just keeping this airline, on getting it to this particular century, there is an expectation that we'll be at least made aware of what it is that are the developments in relation to this particular state asset, or as it used to be, a state asset. So the fact that we are struggling to understand what is going on is a terrible indictment on the government or this administration's commitment to transparency in relation to the administration of public resources. And I think it should obviously leave a lot of people worried about the fact that, well, we might be talking about SAA now, but if this is to become the trend in that the state is going to take money from taxpayers in order to finance particular assets, and then when things go wrong, simply then tell the public that, oh, suddenly you guys are not competent enough to understand what is going on here, so we're not going to let you know, and then get private actor players to then step in and essentially take those assets at prices that very few people even understand, it does set a remarkably bad precedent, particularly if you remember, Sakina, that this isn't the only state asset that is struggling. The struggling state-owned enterprises portfolio is actually made up of many more assets that a lot of people are asking, well, what's the long-term plan? And if this is going to be the way things are to be done, then we are in much deeper trouble as a country.
So just the final one, with all the legal proceedings afoot as well, where do you see this one going?
So, and I think it's probably likely that the Toto Consortium is going to appeal the ruling that we saw yesterday, because some parts of it are quite simply a bit difficult to understand, in that the crux of the question here is that in the absence of access to information, no one can reconcile the decisions that were taken by RMB and the Department of Public Enterprises and the selection of Takatso as the winning bidder. So it's still access to information that is at the core, and that is the critical part of this particular conversation. So the ruling that says, well, you can have access to some particular information, but even that information will only be made available under some very, very thick veil of secrecy, only to people who have a material interest in it. It will simply mean that whatever Toto's lawyers and its stakeholders discover, they would obviously have to come out and say, look, we are now comfortable with the process that the DPE has undertaken, or they'll come out in the alternative and say, now we are even more emboldened in saying that this process was flawed. So obviously, once Toto has looked at this document, they then have to give us some feedback or some insights into what their process is going to be going forward. And if they say that they're comfortable, it really falls upon them to explain to us, well, you said in your allegations that this was the issue. So the only way for you to now say that you've reconciled yourselves to the fact that the process was proper means that X, Y, and Z must have been undertaken. So it does actually open up this information flow, in that no one can simply say, okay, now we're happy, without explaining how we were happy. Because what we saw in the allegations that Toto put together in the court case was that they said there's a glaring information exchange or information flow gap. And if they say that now they're now happy, it would mean that that information has now been made available. And if it could be made available to them, well, why can't it be made available to everyone else? Because the deal would have been finalized, so the commercial sensitivities will no longer be an issue at that point.
Indeed. Khaya, thanks so much for your time. Chartered accountant and political commentator Khaya Sithole.